be out. I don't know what you're doing. Understand what I have here. I let you out. I gave you the opportunity. You create some story that the victim, no. Because you want to believe in him, that's fine. I want to believe in him too. I gave him an opportunity and he has messed this up and is now facing potentially another felon. And I don't know that you even understand that, young man. No, you don't.
Your Honor, there's also the issue of the jail calls that were made. This defendant, while he was in custody, called the victim multiple times. The content of those calls are highly concerning to the people. They suggest witness tampering. The fact that she is not here today kind of completes the concerns we had that his calls and his communication with her have had the effect that he intended them to have.
While in custody, Larry made at least 38 calls to the alleged victim using other inmates' PIN numbers. It gets worse.
Specifically, we have concerns because he gave her a story of what to come and tell the prosecutor's office. She did comply with that, and as counsel is aware, and courts now where she has indicated to us what I would call a recantation, but certainly a different version of events matching what this defendant instructed her to do. There's a lot more to it, including statements he made, tells people that the victim is not coming forward and so on. With all that, Your Honor, we have concerns, so we need to further look into that. Those calls were shared with the public defenders already. I resent the very specific call to defense counsel this morning. I'm going to be listening to those a little more closely. I'm considering witness tampering charges moving forward. And we do have concerns about this defendant being out of custody and the behavior he might have engaged in and may continue to engage in, and making sure the victim does not appear to testify against him.
With the defendant missing from the courtroom, Larry's public defender, Alex Warren Green, faces an uphill battle. He tries bringing up Mr. Larry's family support.
I had an opportunity to speak with my client, Mr. Larry, and Mr. Larry Sr., who is present in court today. Miss Larry was here earlier, and both of his parents really have been calling off work, making every effort to be at all of their son's court dates. I
recall that the last time he was here, they were here. I recall that. Okay.
And in addition to that, I know back on April 27th, Miss Larry wrote a character letter to the court, which I know the court can't consider at this juncture. However, that was sent to counsel, and I reviewed that. And Miss Larry speaks highly of her son. And I think, insofar as Mr. Larry's at a fork in the road, they are committed to make sure he takes the right path and comes out of this continuing the positive work he was doing before arrest in this case. And I would note that this is Mr. Larry's first interaction with the criminal justice system, as far as I can see on his criminal history. When he was released from custody after spending about 30 days in jail, he was placed on home confinement and lives at home with both of his parents. During the time he was in custody, he had to deal with the consequences of being in custody, which included losing his job. His parents want him to get a new job, and I talked to Mr. Larry about essentially scheduling an interview, talking to his tether agent, and seeing if there can be an accommodation made for him to go and do an interview, which I know, if that needs to be done by stipulation or order, I know it's something that has been accommodated in the past. Mr. Larry's enrolling in school. He's Washtenaw County Community College for either CDL, HVAC licensure, but he's trying to get higher education. And I think since he's been out on home confinement, he's certainly not been violating the court's orders.
Well, but the problem is, I don't know that. That's my great difficulty.
When I talked to Mr. Larry's parents, I was very specific about what the court's orders are, including no contact and what no contact means. They ensured me that they're not going to let it happen under their roof. And as far as he's on home confinement, I mean, what they relayed to me is essentially the court's home confinement tether at this point is he'd be on home confinement anyway. They're making sure that he's staying on the right path. They don't want him to end up in jail or, at the end of this case, to be worse off than he was coming into it. So I'm going to ask the court respectfully to consider continuing his bond at this time. Come back on the next date. I've already talked to Ms. Tana about resolving this case. I'm going to talk to my client at length about resolving this case, which, what we pondered does entail further court supervision. But as far as abiding by the court's orders, Mr. Larry and his parents are going to make sure that continues. So
my difficulty is that I believe that his parents have all the best intentions of the world and are probably the most disappointed by all of this. But I myself am very disappointed when I find as I told you, counsel at the bench, I gave him a huge break the last time in letting him out, knowing that there were phone calls. That's come back in certain respects to bite me because I now know that these weren't just, not to minimize them necessarily, but not just context to the alleged victim saying whatever. He was to manipulate the system. I don't even know what's going through his head.
Mr. Larry's father, sitting directly behind him, unexpectedly responds from the gallery.
Scared. Well, he should be, because he's got me right now. He should be scared. Because the grand reality of it is that I can't trust you to be out. I don't know what you're doing. Understand what I have here. I let you out. I gave you the opportunity. You create some story that the victim, no. No. Because you want to believe in him, that's fine. I want to believe in him too. I gave him an opportunity and he has messed this up and is now facing potentially another felon. And I don't know that you even understand that, young man. No, you don't. Why would you put yourself in a position to pick up another felon? You weren't even supposed to be communicating with this person at all. But then you communicate and you go even further to concoct some story. And here's what you have to understand from that. From that, you concoct that story, and then I have no victim here today. She not only takes the story that you give her, communicates it to authorities, then doesn't show.
Your Honor.
Go ahead if you think it's advisable to say something to me, because I am livid right now.
Takes me on the phone with her. What was she? Agreed, such tell me now.
Your Honor, I would ask the court to consider the fact, since Mr. Larry's been released on home confinement, I think almost right away, he got into some level of domestic violence programming. I spoke with Ms. Tana. There's a program that we are both familiar with that I want to refer him to immediately. And to addressing, the underlying allegations here, it addresses those of issues in terms of, it was a bond violation trying to impact the outcome of proceedings, those kinds of things. And I want to make sure that, Mr. Larry's getting to the resources he needs.
But despite everyone's best efforts to protect Mr. Larry, Judge Simpson notices there's one person who doesn't have a voice in this hearing, the victim.
If he's at home on home confinement with his parents, I think he's in a better.
How do I know he's not contacting the victim?
Well, when I spoke to his parents, Your Honor, they advised.
I don't doubt that they're going to do the best they can. I trust them. I don't trust him.
Not contact the victim.
Mr. Warren Green, that kind of choices is available in jail if he wants to start that. Might be advised.
Contact the victim.
Your Honor, my client would just assure the court he's not going to violate any court orders, including the no contact
He
order.
assured the magistrate of that after his arraignment.
Understood.
I was nervous and she was pregnant, so this is my first time, Your Honor.
What?
Your Honor, I think my client's expressing that it is his first interaction with the justice system. He was nervous about the ultimate outcome of this case. It's a big.
What confusion do you have of do not contact this person?
I don't think it's confusion, Your Honor. He admits to violating the court's orders with respect to the no contact order. I think it's naivety, and I think it's him trying to change the outcome of this case. I understand that as far as it's a bond violation. I'm not sure if it rises to a matter where we're dealing with forfeiture by wrongdoing at this point. So I don't want to go too far down that road in terms of what I address, but he knows that's a possibility at this point. And at this point, we're kind of shifting gears and talking to the people about a resolution that involves significant domestic violence programming.
And for the record, I mean, at least 38 calls were made to the victim using other inmates' pins. So being naive, that to me doesn't indicate a naive person. That is deliberately working to kind of fight the system, trying to get out of it. And I agree, trying to affect the outcome of this case. And that's exactly what we're trying to prevent.
And see, it's that behavior why I can't trust you.
Understand her?
Because I don't have a doubt your parents are going to put everything they can possibly put in place to try to make sure you don't mess this whole thing up. But we do the same thing in the jail by giving you a PIN number. And what do? You try to circumvent and go around that whole thing. Then you try to concoct some story, and that comes back. And now you're going to potentially face another felony, as well as proceed without the victim on this case. You don't even begin to understand what the heck you've done. And if you had just stuck by the rules, we wouldn't even be in this boat. I don't need to have this conversation with you. I don't need to try to make sure that the victim in this case can proceed with this case if that's what she so chooses to do.
Okay. 30 days later. Well, that I did. Mistakes were already made. I was 30 days sitting there.
Your Honor, I'd ask the court to consider that the time Mr. Larry spent in custody did have an impact on him. And moving forward, if the court is gracious enough to consider continuing his bond at this point, if he's going to comply with any of the court's orders, but that's going to be a constant reminder as to what happens when he does not. And, I referenced naivety earlier. He didn't think he was going to get caught, and he did. And I think he knows at this point, and his parents well know at this point, if he's caught in violation of his bond conditions whatsoever, he's on thin ice, and it's going to land him back in jail. If it does.
I don't know if he cares, Mr. Warren. I really don't know if he cares. Because if he had cared, he would not have done what he did.
Your Honor, his He's been working on himself a lot. This arrest, hopefully in the long run, going to be the biggest turning point in his life. And that's his sentiment he's expressed to me this whole time. He's got two people that really care about him, that are really going to make sure that he stays on the right track if the court's gracious enough to continue his bond at this point.
At this point, the court has more than enough to send Mr. Larry back into custody. Then Mr. Larry reveals who footed the bill the last time to get him out of jail.
The bond that was posted for you was not your money, was it?
No, sir.
It was your parents' money.
My brother and my sister.
Then you got your family here. Everybody's trying to do everything for you except you. Here's what the problem is, counsel. I've got to figure out, and I've got to give the people time to figure out why this victim isn't here. Do you know how long it may take people to figure out if they're going to bring additional charges against him?
Your Honor, I have no problem reviewing it today. I do need the OIC to do some. So I would ask for it.
I'll adjourn the preliminary exam matter to May 26, 2026, 9 a.m. before me. That's in person. At this point in time, young man, you got to understand, you make your bed, you got to lie in. I'm not going to, don't look at me like this is you.
Right.
Your family put up their money. They did that. Your parents are down here with all their time and everything, trying to stand up for you. And you did this.
Before I already made the mistakes, Your Honor. It was way before that. After I got put in there for 30.
Here's the problem. You've interfered with the whole system. That's the problem. You should have never done any of this. Ever. So if the people would do that, review it, get in touch with counsel, but this time I'm going to revoke his bond. Defendant's remanded. I will consider his release if the people can figure out exactly where they're going to go with this and have the OIC. I'd ask them to hurry up and do it. I don't want to leave him in jail, but he's made his bed and that's where he is now. But I got to figure out that everybody else in this whole system is safe, not just you. You can take it. Dad, don't do it.
Thank you, Your Honor.
Thank you, Your Honor.
Judge Simpson lets the father leave the courthouse. After the hearing, court records indicate that Cameron sat in custody for 3 days. His bond was then set at $10,000, 10%, and a plea agreement was reached. Counts 1 and 2 were dismissed, with a conviction on count 3, aggravated domestic violence. However, there's an important qualifier. This agreement calls for sentencing under Michigan's domestic violence deferral statute. So if Mr. Larry completes the court's requirements, including the 52-week accountable choices program, the case can be dismissed without a conviction. As of this episode, he remains in compliance.